in an earth-moving traffic case in Tennessee, it appears possible that the prosecutor scuttled the case against Brenda Simpson. Brenda Simpson is 77, black, in poverty, and a woman. And she is defending the right of ingress and egress, the right to travel unimpeded, the right to operate not a car, but to use her car on the public right-of-way, not in the operation, not in the driving of a motor vehicle. The charges against her were 5, that she was driving and operating a motor vehicle without registration, without a license, and in violation of the TFRL, the Tennessee Financial Responsibility Law. These cases were all dropped Thursday when it became clear that Mrs. Simpson was not going to buckle. The fact that she did not buckle forced the state to scuttle its own case, and the prosecutor, Neil Thompson, would have found one way or another to do it. I am speculating. This is speculation only. But the errors against her violating the Brady rules were so obvious and so elementary errors that she would have seen them even if she hadn't had other eyes looking at her case with her. And that was the failure to give evidence. The body cams, half of the paperwork was not submitted to her. Possibly 100% of the paperwork had not been submitted to her prior to the trial. And within at least 2 weeks before, she didn't have the materials. So these were obvious mistakes that they laid in front of her to pick up if she was able to do so. And she did pick them up, and she did file a motion for dismissal based on the failure to give discovery. So that was why the case was dismissed. And if there was collusion between the prosecutor, Neil Thompson, and the court, J. Brent Bradberry, it was unspoken. Obviously, it was unspoken because they would have been violating the ex parte prohibitions. Otherwise, you can't have one side talk of anything material with the court without the other side being present. But there is unspoken agreement among prosecutors and judges on how to deal with belligerent claimants in person. Mrs. Simpson was defending herself tooth and nail with excellent defenses that had not been raised before in that part of the state. And so she was saying no, and I'm going to trial. The jury had already been selected when finally the judge realized, well, this case is going forward unless we stop it now. So he dismissed the jury after it had been selected and gave appearance of reading her motion. He hadn't read the motion before, apparently, and so was reading it now with photocopies of some of the printed evidence that was denied to her. She was told by Mr. Jowers, Mr. Thompson's ADA, that she could come by his office on Tuesday and look at the videos for the first time. And the trial was Thursday, so clearly Mr. Jowers knew this would bring her objection, which it did, and the judge ruled in her favor. But the fact that these things were held were usable to scuttle the case. The prosecutor was so scared of this pro se defendant. He was so scared of her that the state obtained from the court a motion for in limine, which was a motion to bar evidence. And the evidence that was barred was Mrs. Simpson's main defense. So the judge snipped out from this black woman's mouth her tongue to make her main defense on the grounds that the evidence was irrelevant. The evidence was the fact that she never got notice of suspension. The reason she never got notice of suspension was because that suspension was part of a fraud run by the Department of Safety, which is the assigning of driver license numbers apart from any application, payment, or signature, the assigning of a driver license number, and then that license's suspension, all without hearing, all without permission, a fraud on the public, apart from statute. There's no statutory authority for this. So seeing that these things were coming into view and that the scam was being exposed, the judge thought the best of it, the prosecutor thought the best of it, and the case was scuttled. Okay, this is just a speculation on my part. I don't have evidence for this, but it seems that we are not to be given court cases or even trials. So the argument to make is in the direction that I'm suggesting. argue that the court doesn't have subject matter jurisdiction on failure of the state to exhaust its administrative remedies. Mrs. Simpson entered a motion in that direction. The judge denied it on the thinnest grounds. He evidently didn't read the law that she cited, but he dismissed it on thinnest grounds. So we have in front of us conclusions based on what I'm saying to you. My conclusion is that don't plea bargain. They were counting on her capitulation, her surrender, her pleading. No, when you capitulate, the machine runs forward against you and against the next person. Okay, so when she stopped the machine from rolling forward upon her, the machine operator jammed his foot on the brake, or so it appears. I think the system is going to have to account for the rights of travel and ingress and egress.